Imagine a SWAT team raids a house, battering doors, breaking windows, and coating everything inside with tear gas residue. Now imagine the SWAT team had the wrong address. Who do you think would pay for the damage? If you said insurance, you're probably wrong. If you said the city, you're probably also wrong. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely and IJ attorneys Jeff Redfern and Dylan Moore. Today they'll talk with us about this nightmare situation facing homeowners across America and how the Institute for Justice is fighting to change it. This is Beyond the Brief. So Jeff, one of the people that experienced this is Vicky Baker in Texas. Can you tell us a bit about that?
Sure. So Vicky Baker's story is pretty typical for these SWAT cases. She's our first client who we litigated a SWAT case on behalf of all the way up from the trial court. Our first SWAT case was one that we took over on appeal. So she owned this house in McKinney, Texas. It's a suburb north of Dallas, and it was on the market. She was relocating to Montana, and it was actually under contract. She was going to close in like a week. Her daughter was at the house kind of finishing up a few last things when a fugitive showed up at her door. Now, she had heard on the news that this guy was on the run from the police, and she knew who he was because he had been a handyman at their house like a year previously. And he must have known that it was on the market or something and figured it was going to be empty. He had a 15-year-old girl in tow, and Vicky's daughter said, I've got to run to the grocery store. Sure, you guys can hang out here for a bit. Pretended she didn't know that there was anything wrong, and then they called the police. Well, the McKinney police showed up with the SWAT team. They surrounded the entire house. Pretty quickly, the fugitive let the 15-year-old girl loose, but he refused to come out. So eventually, the McKinney SWAT team assaulted the house. They blew up the garage door, like literally with explosives. They knocked down the fence. They used these Bearcats.
Which are like tanks, right?
Yeah, they're basically like tanks. And then they absolutely saturated the whole thing with tear gas, like over 60 canisters. And I didn't know this until I was doing these SWAT cases, but it turns out that tear gas is like unbelievably destructive. It's non-lethal, but it basically gets into anything porous and destroys it. So like drywall, carpeting, flooring, all of the personal property in the house pretty much had to be torn out and thrown out. And that was over $60,000 worth of damage, even when she was like half moved out. It turns out when they went into the house, the fugitive had killed himself at some time prior. So the house is trashed. Obviously, the sale doesn't go through, and it turns out the city won't pay her. They say, our police officers acted lawfully, so there's nothing you can do. Her insurance company said, your policy has an exclusion for acts of government authority. And most people don't know this, but this is actually really common. Almost every insurance policy excludes damage done by the government. So our client, Vicky, was like totally out of luck. She thought that she was going to have to, get money out of her retirement accounts to try to cover this and repair it.
So is what happened to Vicky exceptional? How common is this sort of situation?
Nationwide, I think it's pretty common. We hear about a situation like this where it's an innocent owner and a SWAT team trashes the property probably every few weeks. On the other hand, I don't think it's super common on like a municipality by municipality basis. Most of the time when we hear about these, it's like the first time something like this has happened in 10 years in a particular city. So I think that there are a lot of affected people nationwide, but I don't think it's so common that this is something that cities can't afford to pay for.
So what happened with Vicky specifically?
Well, it was a bit of a legal roller coaster. So initially, we sued the city of McKinney in federal court, and we argued that the destruction of her house, of her property, it was lawful, but it was a taking. Just like if the government took your house with eminent domain to build a road or a school or a jail, they destroyed her property for public use to get a dangerous criminal off the street. And the federal trial court actually agreed with us. It said that this is a taking under the Fifth Amendment. It said that some other decisions by other courts had been poorly reasoned on this issue. And we ended up getting about $60,000 in a jury trial for her. But then we went up on appeal to the Fifth Circuit, and that verdict got reversed. It was a surprising ruling because the Court of Appeals basically said that everything that the town had been arguing for getting this verdict overturned was wrong. But
sounds like we win, right?
Right. That's normally how it works on appeal, especially when you are the appellee. Normally they say that you can win on any ground. But the court came up with a different reason that we should lose. It basically said that there's this implied exception to the Fifth Amendment's just compensation clause for government actions that are necessary, is the word that they used.
Where does that come from? Because when you look at the text of the takings clause, it says, nor shall private property be taken for public use without just compensation. It doesn't say, comma, except if the police are doing their job or except in cases of the police powers. So what was the basis for reading in this implied exception?
Well, the Fifth Circuit's reasoning basically, it was based on a lot of common law cases. So there is this defense of necessity to the tort of trespass. So at common law, let's say like you're caught in a blizzard and there's a convenient barn there that you could shelter in. So you break down the door and you take shelter inside. That's private necessity. You're allowed to do it and you're not a trespasser, though you do have to compensate them for the damage you cause because it's better that your life be saved than that someone's lock not be broken. Similarly, if there's like a fire raging through town and you tear down some houses to create a fire break and you save the town, you're not a trespasser and you can't be held liable for tearing down those few houses.
Wait, you as a private person can tear down other people's houses for like a fire prevention?
You can. That's an old common law defense of necessity, but it has to be. It has to actually be necessary to avert this greater good. It's sort of like it's like the trolley problem in torts, and because you make that decision yourself, you're taking a big risk. If you're wrong, you could be held liable. The other famous example is like throwing cargo overboard in a storm to save the ship so that it won't sink. You're allowed to do it, but so you are not personally a trespasser, even though you've destroyed someone else's property in order to save a larger number of people. Well, what the court did was it looked at these old cases and then it basically said, this is just like what the government's doing here. It was necessary to damage this property in order to, promote the greater good. The problem is that all of those old necessity cases are about the private tort of necessity and whether an individual...
Well, and they're about paying, right? Like if you break the lock, you have to pay for the lock, but you're not a trespasser.
Well, that's in cases of private necessity because you got the benefit of it. In cases of public necessity, you're generally out of luck if it's just a private person that destroyed your property for the public good.
Oh, so if I tear down people's houses to prevent a fire, I don't have to pay them for those houses if it's deemed necessary.
That's the old common law rule. Okay. But there are also cases that the Fifth Circuit didn't see, maybe because this issue was never briefed, where federal courts actually said in the 19th century, if the officer, the government officer, takes your property and it's necessary, or destroys your property and it's necessary, he's not a trespasser and he can't be held liable, but the government has to make the property owner whole.
Sure.
So courts have actually distinguished between this private tort defense and the government's obligation to provide just compensation. Because the whole idea of the just compensation clause is that we're taking these benefits, we're taking these burdens, which are public, and sharing them across the entire public. We're not forcing some random individuals to bear these public burdens. One of the examples we use in these cases, we always say that this damage is just one of the costs of law enforcement, and that making Vicky Baker pay for it is like having a lottery to determine who pays like the police chief's salary.
Sure. Yeah. So the individual officers that did this aren't liable, but the city is liable because this is part of the city's general, police force.
Exactly.
Expense.
And this is something that comes up when government lawyers, they always want to talk about deterrence and the idea that, well, police officers in the moment, they're going to hesitate and they might not do the thing that they have to do if they're worried about the cost of this. Obviously, in our immunity and accountability cases, this comes up all the time because in those cases, we really are usually suing the individual officers, even though everyone knows that at the end of the day, they're going to be indemnified. Well, in this case, we don't even have to deal with that fiction because the individual officers are not defendants. There's no way they could be held liable. Like the defendant here was the city of McKinney. And one of the things that we've come across is that actually, more often than not, the police officers, they think that these property owners are going to be compensated. Like Vicky Baker was given a card by the police officers, or her daughter was given a card by these police officers, and they said, look, call this number, they'll take care of you, they'll fix everything up. They assumed that this damage would be covered by the city. And I actually think that the deterrence angle might really go the other way because if police officers are people of goodwill, I think it's just as plausible that they would hesitate to cause this damage in the course of their duties if they knew that doing so would visit financial ruin on innocent people. Like they don't want Vicky Baker's house to be trashed.
Of course.
With no recourse.
And so Vicky thought she was going to be compensated. The officers thought she was going to be compensated. The trial court agreed she should be compensated. And then the Fifth Circuit said, for reasons that no one's talked about and that no one's briefed, we're going to cut the other way. What happened after that?
Well, we filed a spicy brief, but it pointed out that, for one thing, none of this was briefed before. And, the principle of party presentation says that you're not supposed to be deciding cases on a basis that no one ever argued, with some exceptions like jurisdiction. So we didn't have a chance to brief it. And then we explained how they were getting all the history wrong. They missed a ton of material that goes the other way. And they even one of the key cases that they cited actually said the opposite of what they thought it said. So there were a lot of errors in the decision. The Fifth Circuit called for a response, and then it sat for about 4 months. Ultimately, they denied the petition by a 6-11 vote, which is pretty good as en banc goes because, that indicates that the 6 probably think we're right. But just because someone votes against en banc doesn't mean they think the panel's right. Like en banc is a really high bar. So a lot of judges will look at a petition and say, well, it looks like they might have made a mistake here, but I don't quite think this is worth our time. And we only do a handful of en banc cases a year. And then we got a great dissent from denial of rehearing en banc that largely agreed with our arguments. So we're going to petition the Supreme Court for review. And I think that having 6 votes for en banc and a really good dissent is a pretty good platform for that. So we'll see how it goes.
What happened with Vicky? Maybe we can argue about, was it even reasonable for them to, use a tank on her house and throw 60 tear gas grenades in it and whatever. I think we all have potentially opinions about that. But at least it was the right house. And the guy they were looking for was actually in there. That's not the case always. So what are some examples of, it doesn't feel like it can get even worse, but there are even worse examples. So
yeah, it does get worse. So we actually have another case in the Fifth Circuit that came from just outside Dallas in a town called Lancaster, Texas. In this case, a SWAT team commander was hoping to lead his SWAT team to bust a methamphetamine stash house. So he knew basically everything that there was to know about this house. Obviously, he knew the address, but he also knew exactly how the house looked. He knew that it had a perimeter fence and a detached garage that 3 SWAT team members were supposed to raid. He knew the color of the house, and he knew that it had stairs leading up to its front door. But when this SWAT commander, his name was Mike Lewis, went to lead his SWAT team to this house, they all gathered on a front porch, and then Lewis realized, oh, this isn't the right place. The right place was on his left. A house full of innocent people was on his right. But Lewis, for some reason, seemingly just looked to his left, looked to his right, and guessed. And instead of directing his officers to the stash house that he knew the address of and knew what it looked like, he ordered them to raid a completely innocent family's home. And so our client, Karen Jemerson, owned that home. And the SWAT team did what's called a break and rake. So they busted down the door, they threw a flashbang grenade on the front stoop, and they shattered all the windows, raining glass over Karen and her sleeping family.
And these 2 houses look completely different.
They look completely different, and there are a few reasons why that anybody, you don't have to be, a sophisticated SWAT team leader to realize the differences between these 2 houses. So The correct house had a perimeter fence. It had a detached garage. And maybe most glaringly, Karen's house had an impossible to miss wheelchair ramp.
It
should not have been there.
zigzags across the
Yeah,
yard.
there's two exits. One goes to the driveway and one goes to the front path. And the officers had to clamber up this wheelchair ramp to bust down the front door. They had every reason to know that it shouldn't have been there.
So you'd think at some point, right, these officers are walking up the ramp, that they would think to themselves, this isn't on the briefing. How are we here? Why are we moving forward with this? But these officers did none of that. They just proceeded right ahead.
They proceeded right ahead. And I would imagine from the individual officer's perspective, they were probably just following the orders of the commander, even though, they also had reason to know that this wasn't the right place. But really, it's astounding to me that the SWAT team commander could watch his officers clamber up the wheelchair ramp that was not supposed to be there to break open windows and bust down a door, especially when Karen's house had the address numbers right next to the front door. And Officer Lewis knew what the correct house's numbers were, but he even admitted that he didn't really bother to look.
I mean, he already double-checked once. We can't ask him to double-check a second time.
Well, and that makes it even worse because when the SWAT team first lined up and prepared to raid the wrong house, Officer Lewis should have been on notice that they were at risk of going to the wrong place. And if anything, that should make you more careful.
So what happens in the case? We took this case over, right?
Right.
So what did the court decide already?
Right. We took this case over after the Fifth Circuit had already issued an opinion, and we filed an en banc petition that's still pending right now. So basically, what the court said was, sure, this violated the Fourth Amendment, and Officer Lewis actually conceded that ordering this raid on a house full of innocent people violated the Fourth Amendment. But the court still said that he was entitled to qualified immunity, which I think anybody listening to this podcast knows is something that we run into quite a lot. So even though the law was violated, the Fifth Circuit said that it wasn't clearly established that the law was violated. And really, that boils down to a complete misreading of Supreme Court precedent and Fifth Circuit precedent. There's a case from the 80s called Maryland versus Garrison, where police wanted to...
Before you go down that rabbit hole, I just to distinguish this case from the Vicky Baker case, here we're suing the individual officers.
True.
Are we suing the town as well? Just to kind of give listeners a sense of who this suit is against.
Sure. So this lawsuit is just against the officer who ordered the raid. Other officers and the town had been parties to the lawsuit before we got involved, but they had been dismissed. And by the time we got in on it, it was just the Jimersons against Mike Lewis, the SWAT commander.
And so that's the reason we're talking about qualified immunity here, but not in Baker.
Right, because this is just a suit against the individual who ordered the raid.
Gotcha. So the Fifth Circuit granted qualified immunity, and it sounds like they probably misapplied the law. You were about to talk about, I think, a case. What case did they miss?
Sure. So the Fifth Circuit missed its own precedent, but also kind of mischaracterized Supreme Court precedent. There's a case called Maryland versus Garrison from the 80s, where the police wanted to execute a search warrant at an apartment. And this apartment was located on the third floor of an apartment complex. And the cops were trying to figure out if there was one or two apartments on the third floor of this complex. So they did a bunch of research. They talked to the utility company, they talked to the local police, they talked to neighbors, and they did some site visits to try and figure out, is there one or two? And at the end of all of this, reasonable good faith investigation, they just couldn't have known that there were actually two apartments. So when they stormed in, they actually entered the wrong apartment. But it was a reasonable mistake because after all of the due diligence, they just had no way of knowing. So the Supreme Court said this doesn't actually violate the Fourth Amendment because they put in a lot of work into finding out the place that they were supposed to execute the search warrant. But there was no way for them to know that there were actually two apartments in this building. That's not at all like what's going on here. I mean, Officer Lewis knew everything there is to know about the right house that he was supposed to raid. He had pictures of it. He had the warrant on hand. And the houses all had their addresses clearly marked. I mean, it would have taken about 5 seconds for him to make sure that he was directing his officers to the right place. We expect more from pizza delivery drivers and Girl Scouts and plumbers than the Fifth Circuit expected of Mike Lewis.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost-efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
So is this just a, Fifth Circuit problem? Does the Fifth Circuit not know what it's doing? Like, that can't be what's going on here, but sort of, seeing these examples next to each other, it just sort of feels like what's going on over there in Texas.
It does seem to be a Fifth Circuit problem. In 4 other circuits, a claim like this could go forward. And just to reiterate, this is a qualified immunity. Like, this case has been dismissed without actually getting into the heart of the case. So the Fifth Circuit has basically just said, Lieutenant Lewis can't be sued for this at all. We're not even going to go past this. But in 4 other circuits, and I think under that Garrison case, it should be the case in all other circuits, these claims could at least proceed beyond qualified immunity and sort of get into the merits.
So it seems like we have sort of 2 different kinds of cases going on here. I mean, these are 2 of, probably half a dozen IJ cases about these SWAT things at this point. And some of them involve, hey, the police completely messed up in ways that are very, very obvious. And, maybe that's those individuals' faults. And then we have these cases sort of like Baker where, they had the right house, they had the right guy, they were doing, the things that they're supposed to do. And it, sort of falls to the issue isn't what they did. It's just that, now the city has to pay them for the fact that this happened. So kind of going back to that second one, how do you get a city to pay for things?
Well, it's funny because as we started to track these cases, and I have people reaching out to me on a pretty regular basis telling me about incidents like this, what we found is actually more often than not, the city does pay. And no lawsuit has to be filed. Oftentimes there's a bit of foot dragging, and then they realize, okay, like you really were innocent. Why don't we send us the receipts and we'll make sure that it's reasonable, but we're going to make you whole. And I don't know whether these cities think that they're required to under the law, or they just think that it's the right thing to do. I think most people have the instinct that that's the right thing to do. So I think it is a minority of cases where people are just out of luck and have to resort to the courts if they can find a lawyer. We do this, but a lot of lawyers are not going to take a case where the legal claim itself is unsettled. They'll take something where the framework is very clear, and then they can try to extract a settlement. But there's a lot of effort involved in litigating a cutting-edge constitutional case where the precedent isn't entirely clear-cut, and that just eats into your profits if you're trying to make a living as a lawyer doing small damages claims.
And it's tough because if you want to bring a civil rights suit against a city, you have to do so under a case called Monell. And to win under Monell, you have to show that the city had an official policy or custom that led to the constitutional deprivation. And so it can be really, really difficult to prove those things.
I was about to ask, how do you prove a policy or custom in this context? I mean, do you point to a document where the city says, we have a policy of violating your constitutional rights? I don't think many city officials would put that down in writing. So how on earth do you build a record to demonstrate that what the city is doing is pursuant to some policy or custom?
Well, and before actually you answer that, to add to that question, is it that they have a policy or practice of, using tanks and 60 tear gas grenades on your house, or that they have a policy and practice of not paying you after that happens?
Well, so for takings claims, we've argued that it's the latter. Okay. I don't think it's a real problem either way, because ultimately they're defending their actions by saying the police did everything exactly the way they're supposed to. So it's hard to say that's not a policy. But the constitutional violation in a takings claim, it's not the taking of property. The government is allowed to take your property for public uses. Right. And it's very hard to say that we don't have a policy of not paying these claims when your city attorney is in court arguing, we don't want to pay this claim.
Right. Yeah. Like you're doing the thing. Right.
Exactly.
Okay. Okay, sorry, I didn't mean to interrupt your question.
Oh, no. I mean, I think we're kind of halfway through answering it then. So it sounds like with takings claims, at least, it's maybe a little bit easier to prove the existence of a policy because often the attorneys in court are advancing that policy when they're trying to object to paying your client. In the context of a Fourth Amendment claim, I know in the Lancaster case that we're pursuing a suit against the officer, not against the municipality. But what sort of evidence would we have had to uncover to trace that constitutional violation in Lancaster to an official policy of the municipality?
I think there it would probably be something like a failure to train claim, which those are kind of an evidentiary uphill battle, but you can hold cities accountable and liable if you show that they aren't training their officers to respect people's constitutional rights. So I think it would probably be something along those lines because, I mean, to be honest, it's sort of, you won't find a smoking gun of like, we train our officers under our policy specifically to ignore the Fourth Amendment.
Right.
I think it'll be more like, well, the city just didn't brief them up as much as they should have.
And of course, to show that, if I'm remembering correctly, you have to show that the right was kind of obvious enough that the city was being deliberately indifferent to it by failing to train the officer. And then it kind of sounds like we're almost back-ending our way into qualified immunity again, because you have to be able to show that, hey, this violation was so obvious that it was going to happen that the city should have trained its officers accordingly. So it almost sounds like at a certain point, Monell dovetails back into qualified immunity.
It's really frustrating, and that's something that we're trying to fight back against in several of our cases, but it is hard when qualified immunity keeps popping up in places where it doesn't belong.
And Monell, I mean, you're kind of hinting at this, but this Monell problem, it isn't just going on in SWAT raids sort of cases, right? What other context does that come up in?
Monell can come up in pretty much any constitutional tort case. I think that it is most logical in cases where you have lower ranking people who might be going rogue. I mean, the basic idea of it is that municipalities are not supposed to be strictly liable for the torts committed by their employees. But it has become, almost like a parody of that, where unless violations are like actively caused by a mustache twirling like mayor who's like telling people to do things, then you can't hold municipalities liable. And I think the weak version of Monell is not crazy to me. The idea that if someone goes totally rogue, that's not the government. That's a government employee who did something insane.
And like acting outside of whatever his capacity is supposed to be as the
you
government.
hear these stories about like a police officer who's off duty who puts on his uniform and goes and beats up his ex-girlfriend's boyfriend or something. That seems like pretty far afield from government action, even though he might have like used his government tools. But it has become something so much more powerful, where basically it's very, very easy for government to say, well, this wasn't something that we caused to happen directly, intentionally. But more often than not, it is some version of a failure to train. It's negligence. It's a hands-off approach with real indifference to what the Constitution requires. And I think particularly in the context of people like police officers who are dealing with the general public every day in contexts where lots of constitutional rights are relevant, I think it absolutely should be incumbent on municipalities to make sure that they're very, very well trained.
And I want to pause here to emphasize the difference between municipalities and their liability for their employees versus the private sector, which is held to a much stricter standard in the sense that, of course, vicarious liability exists. When a delivery driver knocks over your mailbox, you sue the company, right? You don't sue the individual driver. And the law says that the company is generally liable for the torts of their employees. But when it comes to the government and when it comes to constitutional violations, Monell establishes this stricter, higher bar that's much harder for plaintiffs to prove. Is there any way to make sense of that besides we're just going to treat the government better than we treat private companies?
I mean, I think I gave probably the best defense of it, which is that the Constitution restricts state action, and at some point, there's got to be a bar at which someone who happens to hold a government office is doing something, but they're not really exercising state power. They have gone totally rogue. And I think, we should give remedies to those people anyway. But I at least understand the logic of saying that it's not a constitutional violation when it's not truly government power being exercised.
But if it's somebody just acting, in the course of their employment and they cause harm to somebody else, it doesn't make a lot of sense to me that we couldn't go to essentially their boss and hold the boss liable in the same way we do for private companies. I do think it's really government favoritism.
Yeah, I mean, it seems to me like, whether I'm acting as a government official, whether I'm acting, poorly and maliciously and, as this rogue agent, or whether I'm just, doing my job the way I'm supposed to, or whether I'm just kind of, minding my own business and something happens, it feels like the government should have to pay for that. Somebody made an analogy the other day of, if you're just walking through Target and your coat brushes up against a vase or something, you have to pay for that vase the same way that you would if you were walking through Target smashing vases intentionally, right? And so it seems like that same principle should apply to the government, and it's maybe an uphill battle to make that reality happen in court.
Yeah, it's definitely an uphill battle, but I think it's important to just emphasize how harmful this is to the individuals who suffer at the hands of, whether you want to call it government incompetence, or individual officers' maliciousness, or in the case of Vicky Baker, the government doing arguably everything that it should have done, but still leaving the homeowner with the bag. These are individual people, and not like knocking something over at Target where that's a large company that can sort of eat the loss. I mean, losing your entire home or losing large features of your home as it's destroyed by a SWAT raid, and then just being left totally up the river on that really destabilizes families and makes it a lot harder for them to just go about their day-to-day lives or trust government or other people.
So what is the solution to making people whole when the government violates their rights and specifically, destroys their homes, destroys their stuff, upends their lives?
I think at the very least, if you break it, you buy it. And then we can have further conversations about things like, the effects of the trauma of being raided or how that might affect you and your family. But just at a bare minimum, if government agents in the course of their job, whether they're acting correctly or negligently, break the possessions of innocent owners, they need to be paid back.
So how do we actually get there? I mean, we've talked about some of these cases and we're trying to do this in court and, the deck is very much stacked against us in a lot of ways, but we're getting there. Keith, I know that you're also working on, not to turn you from co-host to interviewee.
I don't mind.
But you're working also on some legislative things.
That's right. So, as always at IJ, we try to litigate cases to win them. We try to change the law through litigation, but we also recognize that legislative fixes are important. And so we've developed model legislation called Protecting Everyone's Constitutional Rights Act, PECRA for short, because acronyms are important. We all know that. And what PECRA says is we're going to create a state cause of action. And it's going to mirror Section 1983. It's going to hold the state liable when its officers commit constitutional violations. But we're going to explicitly hold the government liable. We're not going to be holding individual officers liable. And so it's basically a state's way of saying, we can't fix Section 1983. That's a federal statute interpreted by federal courts. But what we can do is we can open the state courthouse doors. And so PECRA is our way of giving states perhaps the best way to do that. And we've seen some success early in states like New Mexico that have adopted very similar language. And the results that we're starting to see there are positive, right? I mean, we're seeing state government behaving in a way that essentially recognizes that there's now a system of accountability in place. And so, the more states that can buy into that, the more states that can adopt PECRA and other models of legislation, the more opportunities victims of this kind of abuse are going to have. Because as both Jeff and Dylan have shown, like right now, we're kind of in a tough spot with the courts. It's hard to win these types of cases. And so these kinds of state legislative fixes, I think, are going to be, one of the most concrete ways that we can move the ball forward here over the next few years.
But yeah, so that can sound a little bleak on the court side, even though it's optimistic on the
Wasn't
legislative
meant to
side.
be, I promise.
But we are still optimistic about these cases that we're bringing, and we're bringing them even beyond Texas. So, why should we feel optimistic about what's happening in the courts now?
Yeah, so I think on the Fourth Amendment front specifically, there are 4 circuits who have taken the Garrison case I was talking about a little bit earlier seriously and said that qualified immunity doesn't protect officers when they have every reason to know that they're ordering a raid on the wrong house. But even more broadly, it's important to get these cases up in front of the Supreme Court sometime soon so that we can at least have some clarity about what plaintiffs under federal law can and can't bring claims for. So we have cases in South Bend, Santa Monica. It's not just Texas, even though we do have a lot of cases in Texas. But our mission is sort of to get one of these cases, multiple of these cases, in front of the Supreme Court so that there can be some finality about what exactly is protected and how far can the police go before they have to start answering for what they've done.
Right. It's not even that we need to get Monell overruled, though it would be great if we could. It's just that we need to get the crazier interpretations of Monell overruled. There are cases that apply Monell in a way that is not totally crazy, even if it's not a precedent that we love, and a lot more cases could go forward under those precedents. In the Fifth Amendment, the SWAT takings context, I think there are a lot of reasons to be optimistic. There really aren't that many precedents out there. And significantly, even though we've lost a few cases, we're not losing them in the same way. It's like every time we have a new case, the new court disagrees with the previous court and comes up with a different reason. And then we have to explain why that reason is also wrong. But eventually, they're going to run out of reasons for us to lose these. I think it's also significant that Texas and Minnesota, as a matter of their own state constitutional law, already require compensation for claims like these. So it really demonstrates that the rule that we're asking for is entirely workable and hasn't caused major problems. So I think that, if the case goes to the Supreme Court, I think we absolutely win. I think the question is just getting it there and getting a really clean split. But no one has come up with a really persuasive reason why under a normal understanding of the Fifth Amendment, those claims shouldn't go forward.
Yeah, it seems like courts are kind of reflexively understand what's right. What's happening here isn't right, and they just kind of need to sew up all the holes around it so that they can get to the right answer.
Yeah, I mean, there's this version of the old judicial conservative who every time they see a constitutional claim, they think that their job as a good judge is to reject it unless there's a case on point that absolutely ties their hands and forces them to accept it. So, we've run up against a few of those judges, but, I'm hopeful that we will eventually exhaust their endurance.
Sounds great. Well, thank you so much, guys, for joining us today.
Thank you.
Thanks for watching today's episode. We got a lot of great comments on our last episode, so let's dive in and respond to a few. Tay Zonde of Chocolate Rain fame writes, "It's astounding that items criminally disappeared in the process of inventorying them for alleged crimes." Well, that's exactly right, Tay. At every stage of the raid on U.S. private vaults, from planning to executing and documenting the seizure and instituting forfeiture proceedings, the FBI's failure to comply with the Constitution is truly astounding. You might even say it's enough to make angels cry and shake their heads in shame. And if you don't get that last reference, do yourself a favor and Google Chocolate Rain to check out Tay's immortal contribution to viral internet videos. Thanks for watching, Tay. F. Leonard writes, "See, Grandma stuffing her mattress with cash wasn't so crazy after all." Maybe Tempur-Pedic needs to think about using a new slogan. Great sleep, even better protection against FBI raids. KLW III writes, "Steve Leto brought this case and many others to my attention. He is such a strong supporter of the Institute for Justice, and I donate to them as much as possible. They are one of the few organizations that fights for the little guy." Well, thanks for your support, KLW. We're big fans of Steve Leto's work too, and we appreciate all the attention he helps bring to our cases. On issues like forfeiture, it's important to talk about what's happening and why it matters, because far too often, the government gets away with abusing people's rights when they do it quietly and discreetly. Voices like Steve Leto's helps to bring these issues to light, and we're so glad that he led you to us. Rex Parker writes, "Why can't the FBI be charged with crimes and send people to prison? Why can't the FBI just be sued for damages above returning property and charged punitively if they don't return that property?" That's a great question, Rex, and the answer is a little complicated. Contrary to what you might see in movies and TV shows, victims of crimes don't always get to decide whether to press charges against the people who harmed them. Instead, those decisions are made by state and federal prosecutors. And because those prosecutors work alongside the government officials who harmed you, they're considerably less likely to bring charges against them when they do. The result? Most government officials who violate people's rights in a way that violates criminal law don't get charged, much less convicted. And the reason that it's difficult to sue the FBI for monetary and punitive damages is because of a doctrine called sovereign immunity, which draws its name from the idea that the sovereign king can do no wrong. Sovereign immunity effectively says that you don't get to sue the government for damages unless it expressly allows you to do so. And as you might guess, the government doesn't do that all that often. And that's why suits against individual officers and the legal doctrines like qualified immunity that prevent them are so important. They're often the only way for a victim of government abuse to be compensated or made whole for past misconduct. That's why IJ fights so hard to convince courts and legislatures to end qualified immunity and give everyone the chance they deserve to vindicate their rights. Batman2099 writes, "I got a question. Doesn't asset forfeiture law violate a part of the 14th Amendment where it says that you can't be denied your property without due process?" Thank goodness you're here, Batman. You're absolutely right that one of the biggest problems with civil asset forfeiture is that it violates due process, often in more than one way. Sometimes the government will seize property and hold on to it for months before property owners get an opportunity to contest that in court. Other times, the government won't give property owners any idea of why they took the property in the first place, making it difficult, if not impossible, for the owner to figure out the best way to get their property back. Some other times, government has financial incentive to forfeit property because the law allows the government to keep the proceeds. We think all of this violates due process, which is why we at IJ are always trying to bring new cases challenging the different ways that government tries to forfeit property without following the Constitution. With your help, we hope to one day put an end to it. Maria Mango writes, "Why is carrying cash in itself a crime?" Well, carrying cash isn't a crime, which is why the government's decision to seize and forfeit it is so problematic. Most of our cases involve people who are traveling with cash and who are stopped by TSA agents, Border Patrol, or even sheriffs, and have their money seized. The government claims that it's because carrying large amounts of cash can indicate that a person is involved in certain illicit activity, usually drug dealing. But lots of people carry cash for purely lawful reasons. Past IJ client Kermit Warren flew with cash from New Orleans to Ohio to buy a new tow truck for his business. But Ohio DEA officials stopped Kermit and seized his money, claiming that he was using it to buy drugs. That's when IJ stepped in and helped Kermit get his money back. Traveling with cash isn't illegal, and it's not a reason for government officials to stop and harass law-abiding citizens, much less try and take their hard-earned money. Well, that's all for today. Thanks again for watching, and make sure to subscribe and tune in to our next episode.